The world of NASCAR has been rocked by a recent legal battle that's pitting two prominent racing teams against the sport's governing body. 23XI Racing and Front Row Motorsports have taken a bold stance, challenging NASCAR's authority in a way we've rarely seen before. This confrontation has far-reaching implications for the future of stock car racing, and it's crucial to understand the nuances of this complex situation. Let's start by examining the foundation of this dispute: NASCAR's charter system. Introduced in 2016, charters are essentially franchises within the NASCAR Cup Series. But what exactly do these charters entail? They're not just pieces of paper, they're golden tickets that guarantee teams a spot in every race, a share of the prize money, and other valuable protections. In essence, charters are the lifeblood of NASCAR teams, providing financial stability and competitive advantages. So why would 23XI Racing and Front Row Motorsports risk their standing by refusing to sign a new charter agreement? The answer lies in their accusation that NASCAR has become a monopolistic bully. These teams believe that the current system stifles competition and leaves no room for fair negotiations. As a result, they've taken the unprecedented step of filing an antitrust lawsuit against NASCAR. The teams argued that the current system stifles competition and leaves no room for fair negotiations. As 23XI stated in September 2024, "We did not have an opportunity to fairly bargain for a new charter contract." The charter system works as a franchise agreement, offering guaranteed race entries and revenue sharing. Considering this provides financial sustainability, the stakes were incredibly high for the teams. Losing charter status meant potentially racing as an open team, which comes with significant disadvantages. This brings us to the recent court ruling that has shocked the motorsports community. U.S. District Court Judge Kenneth D. Bell granted a preliminary injunction in favor of 23XI Racing and Front Row Motorsports. But what does this legal jargon mean in practical terms? Simply put, Judge Bell's decision allows these two teams to compete as chartered teams in the 2025 season, despite their refusal to sign the new agreement. It's a significant victory that ensures their continued participation at the highest level of NASCAR competition. But why did the judge rule in their favor? Judge Bell's reasoning centered on two key points. First, he emphasized the public interest, stating that NASCAR fans, and members of the public who may become fans, have an interest in watching all the teams compete with their best drivers and most competitive teams. This acknowledgement of the fans' perspective is crucial, as it recognizes the broader impact of this dispute beyond just the teams and NASCAR. Secondly, the judge saw merit in allowing the antitrust legal challenges to be considered. This opens the door for a deeper examination of NASCAR's practices and could potentially lead to significant changes in how the sport operates. Judge Bell went so far as to state, "The court finds that NASCAR possesses monopsony power in the relevant market." This is a huge win for Michael Jordan's team and FRM as they get past the injunction hurdle, secure their charters, and get clarity on the judge's stance on the lawsuit. The implications of this ruling are far-reaching. For 23XI Racing, co-owned by NBA legend Michael Jordan and NASCAR star Denny Hamlin, it provides much-needed stability. The team's star driver, Tyler Reddick, who finished fourth in the 2024 Cup standings, had an opt-out clause in his contract that would have been triggered if the team couldn't secure a charter for the 2025 season. Similarly, Bubba Wallace, another key driver for 23XI, had expressed concerns about his future with the team if their charter status remained uncertain. As the judge wrote, Wallace had informed his team he needed to know how it intended to compete immediately so he could explore options with other teams. Front Row Motorsports, owned by businessman Bob Jenkins, also breathed a sigh of relief with this ruling. Both teams now have the green light to not only continue competing but also to expand their operations. They've been granted permission to purchase additional charters from Stewart-Haas Racing, which closed its doors at the end of the 2024 season. In a recent breakthrough, 23XI Racing and Front Row secured another big win in the lawsuit. The court not only granted a preliminary injunction allowing both teams to retain their chartered status while the lawsuits proceed, but also approved both teams to purchase the charters from Stewart-Haas Racing SHR. SHR had 2 charters, and 23XI and Front Row secured 1 charter each. This solidified their position in the 2025 NASCAR Cup Series. The reactions to this legal victory were swift and jubilant. Denny Hamlin took to social media with an exuberant "Yes!" Shh. while the ownership of both 2311 and Front Row Motorsports released a joint statement expressing their satisfaction with the court's decision. But what about NASCAR? Their response or lack thereof speaks volumes. The governing body has yet to comment on the ruling or indicate whether they plan to appeal. This silence leaves many questions unanswered and adds to the uncertainty surrounding the sport's future. The financial stakes in this legal battle are enormous. Bob Jenkins revealed that without charters, the two teams stood to miss out on a combined $45 million in revenue. This staggering figure underscores the importance of charter status and explains why these teams were willing to take such a drastic step as filing a lawsuit. Let's examine the legal arguments from both sides in more detail. The teams contend that NASCAR's practices are monopolistic and that charters are necessary to fulfill their contractual obligations with sponsors and drivers. They argue that competing as open teams without charters would cause significant financial losses and competitive disadvantages. Charter agreements are pivotal in NASCAR as they guarantee race entries, a share in prize money, and increased sponsorship opportunities. Without a charter, the team competes as open entries. This amplifies the uncertainties and removes the guaranteed spots, also resulting in significantly lower earnings. Open teams, unlike chartered ones, have to qualify and are not assured a spot. This scenario makes it harder to attract sponsors. The charter system is modeled after franchise structures in major sports leagues. NASCAR, on the other hand, maintains that the teams simply dislike the terms of the final charter agreement. They've asked for the lawsuit to be dismissed, arguing that the team's grievances don't constitute antitrust violations. NASCAR had been operating with 36 chartered teams and 4 open spots since the charter agreement began in 2016. The legal proceedings have seen some interesting developments. Initially, U.S. District Judge Frank D. Whitney denied their request for a preliminary injunction, stating, "The plaintiffs have not sufficiently demonstrated immediate and irreparable harm if the charter remains in question." However, a change in judge to Kenneth Bell flipped their fortunes. This case has broader implications for NASCAR as a whole. It challenges the very foundation of the charter system, which has been in place since 2016. If the teams ultimately prevail, it could force NASCAR to overhaul its revenue-sharing model and rethink how it governs the sport. Currently, NASCAR receives 51% of revenue from broadcast contracts, while teams earn 39%. Tracks get the remaining 10%. Other teams will be watching closely, as the outcome could impact their own negotiations and operations in the future. The judge's emphasis on the fan experience is particularly noteworthy. By highlighting the public's interest in watching a full slate of competitive teams, Judge Bell has placed the spotlight on the importance of maintaining a balanced and exciting sport. This focus on the fans could potentially influence future decisions and policies within NASCAR. So, what's next in this legal saga? NASCAR has the option to appeal the ruling, but as of now, they haven't indicated their plans. An important date to mark on the calendar is January 8th, 2025, when there will be a hearing on NASCAR's motion to dismiss the antitrust lawsuit. NASCAR has filed an emergency motion for a partial stay of the ruling. They argued they didn't have adequate opportunity to explain the complexities involved in charter transfers before the ruling was made. In their filing, NASCAR claimed that the organization would suffer irreparable harm without a stay. Interestingly, this legal battle has coincided with discussions about potential changes to NASCAR's playoff format. NASCAR COO Steve O'Donnell recently suggested that the organization might use artificial intelligence to help design a new playoff system. This idea has been met with skepticism from some within the NASCAR community. J.R. Houston, an engineer for 2311 Racing, criticized the suggestion, saying, "It's unfortunate that the tagline of artificial intelligence is just slapped onto anything now." Golf clubs designed by AI was a funny one I saw today. Simple terms like asterisk math asterisk and asterisk statistics asterisk just aren't sexy enough. Playoff format designed by AI is such cannon fodder. The use of AI in NASCAR isn't entirely new. Some teams, like Richard Childress Racing, have been using AI to execute more efficient pit stops. They use in-car transponders and a camera mounted on the pit box to precisely determine the car's entry into the box. This allows them to calculate exactly how much fuel the car should be getting during a pit stop. If you enjoyed the video, please like, comment, and subscribe to our channel to stay updated on upcoming content.